I asked you if it was political speech, and that was kind of a fundamental that stuck in my head. It's not private sector. There are isn't there a hierarchy of speech?
The Supreme Court in the past has created a hierarchy and said that speech about certain subjects is especially important, and therefore we should be especially suspicious of restrictions on that kind of speech. And the court traditionally has said that political speech, which it defines more broadly than just the way we would use the term political in everyday language. It's not only directly related to politics, but it's speech about any matter of public policy, is especially important in a democratic republic. And one statement the court made was speech about public matters is more than self-expression. It is the essence of self-government. Now, so it's still a factor that would weigh in favor of protecting speech, that it's got a public policy dimension, but that turns out to be a rather unworkable distinction, Doug, for this reason, that at the lower end of the hierarchy that the Supreme Court has created is sexual expression, which traditionally has been treated as a stepchild of the First Amendment. And yet think about all of the types of sexual expression that involve very pressing matters of public policy, from abortion to gender issues to sexual harassment.
I don't think about all that
It's
much.
an artificial distinction.
Being a man, maybe I don't think about that.
And so what's happened is that in recent decades, the court has pretty much abandoned those former hierarchies and across the board become more and more speech protective of speech about every topic. And there's only one isolated exception that has become more and more anomalous when you see how speech protective the rest of the jurisprudence has become, and that is the so-called obscenity exception, which the court created in 1957, revisited in 1973, upheld the exception by the narrowest 5-4 vote, and has never since returned to the issue. Meantime, all these decades later, it's become more and more speech protective about types of expression that formerly were not protected, including so-called commercial speech and extremist speech and terrorist speech, but it's never gone back to revisit that obscenity exception, which becomes more and more of an outlier that doesn't make any sense in light of the rest of their jurisprudence.
Well, maybe they're just not enforcing it, and they have better things to do.
Yeah, I think that's what's happened. Because one of the elements of the obscenity exception is that it has to be, for material to be deemed to be obscene and therefore excluded from First Amendment protection, it has to be judged by contemporary community standards to be patently offensive, among other requirements. And I've read that as we've become increasingly tolerant, as media have exposed us to more and more varieties of expression, including sexual expression, it's become increasingly impossible for prosecutors to get juries to convict, even in parts of the country that used to be quite conservative, such as Utah.